All right. We are all set with work.
Morning, judges. My name is Toyina Hargret, and I represent the city of Tampa, who is the defendant below, who we appellant here. The city is here as
I'm not sure, maybe it's my hearing today. Let's see if you can speak a little louder. Let's see if that works.
okay. I'll try. Is that a little bit
That's
better?
much better. Thank you.
Okay. All right. Well, again, I'm Toyina Hargret, and I represent the city of Tampa. We were the defendant below and the appellant here. I'd like to go ahead and reserve 5 minutes of time in order to provide a rebuttal if necessary.
Very good. Just make sure and keep your voice level up for me.
I'll keep that. Usually I'm really loud, so I'm trying to moderate that. But
When I did oral arguments, I never seemed to have a problem being too loud, but I appreciate it.
okay. Well, I'm hoping that this won't take the full 20 minutes because of some of the straightforwardness of the arguments being presented by the city. First off, this was an underlying trial that had to do with the motor vehicle accident where the city admitted negligence, the negligence of our law enforcement officer. Our officer improperly made a U-turn heading northbound out of Nebraska, and the plaintiff unfortunately was a passenger in a vehicle that was unable to stop. At the scene, the plaintiff did not seek any medical treatment. A few days later, solicited the assistance of 1-800-411 pain and procured some chiropractic treatment. This act, and I don't think I mentioned this, but just for the record, the accident occurred in August 23rd of 2013. By the end of the year, the plaintiff began treating with an orthopedic surgery who on day one said that the plaintiff was in need of surgery and estimated $50,000 to $70,000 in cost for the surgical treatment. The orthopedic surgeon went ahead and gave a series of epidural steroid injections that December 2013 and January 2014. And the plaintiff essentially kind of dropped off the radar for about 3.5 years.
So let me ask a question that I think goes to the heart of at least what you're addressing now. Your brief makes the point that there is differing testimony by each party. The jury obviously believed the plaintiff's expert to some degree. Well, they did. They awarded $150,000 and they found that those expenses were reasonably incurred, right?
And that is the heart of the issue, Your Honor. What the jury did was the jury found that there was no permanent injury. And the significant part of that is that the plaintiff's absolutely not. It does not.
Really just talking about $50,000 for the future.
We are not limited just to the $50,000 for the future. We also still can consider the fact that under 768-043, the evidence admitted at the trial level still needs to support what the jury did. And specifically here, there was no testimony regarding treatment or the cost of.
He did have surgery in 2018.
He did.
And his surgeon attributed the need for surgery to the 2013 accident.
And the surgeon also tested, correct, and the surgeon also testified that that need was based upon a permanent injury. So given the fact that the jury rejected that,
Permanent injury arising out of the accident.
yes,
And the jury concluded it's not permanent,
absolutely.
but is there any indication based on the verdict form that the jury did not find or did not consider that nevertheless, even though it wasn't permanent, it was still an injury caused by the accident? The answer is no. There's no.
Well, no, it's not a specific line item question.
There's the difference of testimony between the IME doctor, Nikovich, if I'm saying that correctly, and Dr. Bono.
Yes,
One says it was necessary, one says it wasn't.
well, the distinction between the two doctors is that one, Dr. Bono says that it was a permanent injury. The distinction, the difference with Dr. Ganesevich is that he says, no, it was temporary. And not only that, but that if it's just a sprain or strain injury that we're talking about here, the treatment for that is basically analgesics, stretching, all that
That's a
stuff.
difference of opinion between the doctors.
Absolutely.
And that's a determination for the jury. Would you agree to that?
That was, and that was determined in the city's favor when it determined that the plaintiff did not suffer a permanent injury. So the issue then becomes, if there's no permanent injury, what evidence is there to support treatment and cost damages for a non-permanent injury? There was none, and that's the issue.
I'm confused.
There
If
was,
there's testimony that surgery was necessary as a result of the accident, whether it's a permanent injury or not, is that not compensable?
no, it's not,
Why not?
because it's not relevant.
If you were injured from an accident and there's a disagreement as to whether the injury is a permanent injury or a significant but not non-permanent injury, and there's testimony that surgery was required to address this injury, and the other side says surgery is not necessary, isn't that clearly a jury question?
It is, but I think what I'm not conveying, is that Dr. Bono said that the need was based on a permanent injury. He wouldn't have done it other than for a permanent injury. And if the jury found that there wasn't one, then he's not entitled. Then the sequela, the continuation of accident, permanent injury, then surgery is broken. The treatment, the surgery is not causally related to the accident. The city's experts testified completely different.
The doctor said, their doctor said it was causally related.
The plaintiff's doctor
Plaintiff's
said
doctor said it was causally related.
it was, which was rejected. And so that's the city's
No,
point.
causation was not rejected. The jury found that there was causation.
Not for a permanent injury, only as it relates to a temporary or transient sort of condition. And I think that's really the crux of it. The city is before you saying that if you take, and I don't think I mentioned this, but I'm clearly aware that this panel knows that there was a directed verdict awarded as it relates to aggravation because of the fact that Dr. Bono didn't have any testimony, any medical records related to a pre-existing or subsequent injury. He completely determined that this surgery was necessary because of the accident. Since the trial court granted the city's motion for directed verdict on the aggravation, what's in front of the jury, and they didn't argue it, the plaintiff was unable to argue it because of this directed verdict. What was in front of them was determining just whether or not the injury was permanent and or what injury was there.
Regardless of whether they determined it to be permanent or not, past medical would still be compensable because there was testimony in the record that the accident caused the need for the surgery. Right?
On a fundamental level, I agree with you that yes, it's true
I'm
that
only asking for a fundamental level.
okay. Well, but then on a more, high level where maybe possibly even sometimes esoteric, the issue then becomes, well, and let me just say it like this. The way that 768-043 works in the city's estimation is that it's almost self-regulating. If you take a look at the evidence and you were to represent that evidence related to the damages, what was there to present? If we've got no aggravation and we've got no permanent injury, what could they present? There's nothing, because their doctor, Dr. Bono, said, everything I'm going to tell you about here today in front of this jury has to deal with a permanent injury. I have no testimony for you, no opinion. I've completely rejected the idea that it's temporary. But that is the premise that the jury accepted, that it is a temporary injury. It wasn't permanent. And so what do you have?
How does that translate into the surgery was unnecessary?
The surgery could have been necessary, but the surgery was necessary because of the pre-existing injuries. There was plenty of testimony that established that.
Would we be helped with an interrogatory verdict form as opposed to the broader general verdict form that was used in this case?
Well, it's always better to have more questions because then you get more into the nitty-gritty of what exactly it was that the jury was thinking. So to that question, yes, but was the verdict form deficient? No, because it still asked the essential questions, which dealt with permanency, which was rejected by the jury. The jury did find, though, what amounts of the damages were, but they found no permanent injury. And so we believe that this is precisely the type of case that the 768-043 requires you, the trial court, to look at again. And again, it is kind of self-regulating when you look at the fact that the trial court herself indicated, I don't know where they came up with these numbers, where in the record, and that's what 768-043 requires you to do. Find out where in the record point to me, line and page witness, whatever, where in the record can we establish that there were damages related to non-permanent injury? So I think that the distinction that I'm trying to bring is that Dr. Bono never testified about it. The plaintiff's orthopedic surgeon never testified about anything temporary. There was a chiropractor that did treat the plaintiff. However, that chiropractor did not testify. And while the plaintiff did submit some records regarding the treatment of the chiropractor's treatment notes don't establish that they were made within a reasonable degree of medical certainty. So it still wouldn't be sufficient to support, damages related to that.
So the crux of your argument is that Dr. Bono's testimony was an all or nothing.
Exactly, it was all or nothing. And
So the jury couldn't try to sift through it and accept some of it and reject another part of it.
yes, because there was nothing to sift through. For the purposes of determining that, okay, there's no permanent injury, there's a temporary injury, then the jury could have listened to Dr. Knesset, the city's expert, and the city's expert talked about that 90-day time frame. That 90-day time frame would have allowed them to sift through some of the records and provide the chiropractic treatment and even the treatment for the epidural steroid injections. Those are things that they definitely could have looked at, and those would have supported finding damages related to a non-permanent injury.
Let me ask you a question. Suppose the plaintiff's lawyer decided to concede that it was a non-permanent injury, but continued on with the argument that was made that the need for surgery was caused by the accident, and conceded that it wasn't permanent. Would they not still be allowed to recover their costs and expenses for the surgical procedure, regardless of the fact that they weren't arguing that it was permanent? Let's take permanency out of it. And I understand your frustration perhaps that we go 4 or 5 years with no treatment, and all of a sudden there's a surgery required that relates back to something that happened 5 years ago. It's odd, it's peculiar, but that's not what the appellate court looks at.
Well,
That's a battle between Knesset and Bono.
it is, but because of the way that the testimony was framed by Bono, that the need was for a permanent injury. I mean, I apologize for repeating myself, but because of the fact that the need was for a permanent injury, I don't think you can take the permanency out of it. He's saying that his treatment was relevant, reasonable, necessary because of the accident. And the jury said, no, it's not a permanent injury. So therefore,
That's not what the jury said though. I mean, in your motion for remitter, your client has in the motion, to the contrary, Dr. Bono testified that plaintiff's injuries at January 24th surgery as L4, L5 performed 3.5 years post-accident were solely attributable to the August 23, 2013 accident. So if he testified that way, which the record reflects he did, he doesn't say, but the surgery was only because it was a permanent injury. He says the surgery was necessitated because of the accident. And why can the jury not hang their hat on that? I'm still puzzled by that.
because that testimony still conjoined with the fact that it was necessary because it was a permanent injury.
No, it was necessary because he was injured in the accident.
Well, that's not really the way that he testified.
Well, I'm reading your client's argument that he testified the surgery and his injuries were solely attributable to the August 23, 2013 accident. He
Well,
doesn't say if it's permanent or only necessitated because of a permanent injury. We might disagree with the jury in terms of whether this was a permanent injury or not, but that's not our role. The jury found it was not permanent, but they were asked to find in the verdict form, what was the amount of, was there negligence? Yes. What's the total amount of damages sustained by Brunson for medical expenses in the past? They put a number in there, and that number seems to be supported by the evidence as presented.
but then even if we move past this particular issue and you look at the numbers that they provided, where did the numbers come from? And there's no
I
evidence.
agree there are numbers in the record supporting in excess of $200,000 of injuries relating to the accident. I think you have to agree.
I do.
That the bills are,
200, yes.
okay.
Yes, in excess of $300,000. There were some different, but then you say to yourself, well, then where did these numbers come from? They're not supported by any testimony given by any doctor. You've got the different.
I think I understand your argument. Do you want to address future medicals? You're almost. to your
Well, the
5
future
minutes.
medicals, I think, are a lot clearer because of the fact that Dr. Bono testified that there was no treatment that was required for a non-permanent injury. It was couched in terms of permanent. So I think that those two arguments are kind of similar, but it's just a lot clearer on in relation to the future issues. So with that, we believe that the amount awarded by the jury was excessive as well. And when you go through the factors, you see that it must have been based upon some sort of conjecture in order to get to that $50,000 number.
And you're at your 5 minutes, but if my colleagues have any more questions, I didn't want to cut them off. Very good.
Good morning, Your Honors. May it please the court. I'm Thomas Burns, and I represent Sheriff Brunson. The city's instruction and verdict form correctly told the jury to calculate economic damages without regard to injury permanence.
Justified $50,000 future award.
I was going to jump there in 30 seconds. So there are a number of places where they're talking about future diagnostic things that you would need to have done.
That there's testimony that there would be a need for future MRIs.
Yes,
I didn't find any dollar amount affixed to that testimony.
it's in the bills, and you could extrapolate that over the future. So
You're saying go back and look at MRIs that were previously conducted
and extrapolate. Correct.
But how do we know how many MRIs we're gonna need and what frequency and whether the cost is still the same, all of that?
Okay, so both experts agreed that they should be done every 2 or 3 years. So let's take the best number, every 2 years. That testimony was a transcript 161. That's Dr. Bono, and transcript 542. That's Dr. Knezovich. MRI, depending on whether you're getting cervical and lumbar, and cost between $22.40 and $44.80 each. So let's take the best number, $44.80 each times 10, $44,800. Dr. Bono said you needed x-rays every year. The most expensive x-ray listed on the bills was $384 a year. You multiply that for lumbar or cervical, so double that, and then times 10 years, that gets you either, depending on whether you're doing the one or the both, to $7,680 or $15,360. Either of those numbers push you above $50,000 just with x-rays and MRIs. If you're talking about painkillers, I think it's within the realm of the jury's knowledge that that's like $10 a month, $10 a month, 240 months, $2,400, again, pushing you well above $50,000. If the jury thought that he needed injections, as like a thing, the bills showed the injections were $2,320.13. That could be done 1, 2, or 3 times a year. That could add up to about $7,000. Now we're above $60,000, maybe even to $65,000.
So, Mr. Burns, what case stands for the proposition that the jury can rely on past medical expenses to calculate future medical expenses?
I don't know.
That's the argument you just made.
It is a case, but I'm not sure that there's a case that says that. So
There are cases that say the opposite.
Are there? Because I didn't see that. The cases that I saw.
The Hitchcock case out of the 5th PCA, which cites a case from this court, says the amount of past medical expenses incurred does not, at least by itself, provide a reasonable basis for a jury to compute future medical expenses.
Is that with testimony saying that there's the necessity for futures, or without
This
it?
case was cited in the briefs. Did you read the briefs? From the other side? Did you read the Hitchcock case?
The Hitchcock case, I don't remember. The cases that I was seeing about that issue were there's a case in this court, now Justice Kennedy, a couple of cases by Judge Kelly, and one case by Judge Wallace. And they're saying, when you're talking about the futures, there wasn't enough evidence, or there wasn't enough certainty with the testimony. The doctor said this was
Is there a
reasonably
case that says a jury and a plaintiff can rely on the cost of past medical expenses to determine the amount of future medical expenses.
I'm not aware of one, but I don't see
So
why that
if
would
this
be.
case that I just read to you from Hitchcock says what I think it says, then you have no case to contradict that.
Not here, but the jury was instructed to use its,
The case law seems to be very clear. You can't rely on past medicals to come up with some number as to what it might cost in the future. But
I
that's
don't-
why we have
so-
experts, right?
well,
Okay, this is reasonably necessary. Here's what it is likely to cost reduced to present day value.
okay, so this is a case out of the 5th district.
So it's a case out of the 5th district that cites to a case out of this court.
Okay, so number one, I'm not aware of a case that says the argument that I'm making. Number two, I'm not persuaded by,
Very, very good, that you're making this kind of piecemeal thing, well, this cost is around, or do kind of the issue. That sounds more like a closing argument in a trial based on evidence that was elicited during the trial, rather than that's not your role here. Just remember, the numbers you're giving us are based on your speculation about what might occur.
no, the doctors did say what would happen. They didn't just add that extra
They
sentence.
said it's going to go on for 10 years and this is what you get 50,000 cost.
The testimony you need to look at, the closest that I saw was, I think, at 161 and 542, and then there's another place in the brief where I say he's getting into what would need to be done. He doesn't add and X-ray for Dr. Bono X-rays every year. And then the jury goes back, obviously, to get together to decide the case, and they have all of the evidence. So they can take, in my view, they can take that testimony, they can take that evidence, and then they can calculate the number, because their job is to just calculate what's reasonably certain based on that testimony. I think that complied with what the Supreme Court had said in auto owners. This is you need to have reasonable certainty, and I think that's consistent with the line of cases that I was talking about with Judge Cantor, not Justice Kennedy, Judge Kelly, and Judge Wallace. I'm just not familiar with that 5th district case. I'm not persuaded.
And I do owe you an apology. That was 5th district case, but it's cited to another 5th district case, not the 2nd DCA.
Okay, I'm not persuaded by the holding of that case. So that would be my other argument, that I don't think that's correctly stating the law. But so I think we're kind of approaching this correctly. You need to look at the past medicals separately, and you need to look at the future medicals separately. I think the past medicals are really pretty clear. We have Dr. Bono saying it's reasonably necessary. The jury agreed with that. That has nothing to do with injury permanence. If the city wanted the jury to make a determination of that based on injury permanence, they needed to propose instructions that said that, they needed to propose a verdict form that said that, and they didn't do that. That leads to an an invited error problem, and an error preservation problem. With the future medicals, we've been talking about that as well, but there's kind of two lines of arguments, and one of them I view as a true love style of argument, where there's kind of what we've just been talking about, whether there really is reasonable certainty of these future damages. And then there's a separate part of it where the city's saying you can't get these things because there's no permanent injury. And to the extent we're talking really about an inconsistency between the jury finding no permanent injury and inability to calculate certain things, that's an inconsistency in the verdict that must be raised before the jury's released from its service. So that argument just can't go forward. In fact, the first DCA has been crystal clear on that in the Herald case. If you were to disagree with that, you would have to certify conflict with the first DCA. In the fourth DCA, there's a little bit of a sort of a mix-up. There's the FDOT case, FDOT against Stewart, that's the 2003 case, and there's the subsequent case, Progressive Select Insurance Company against Lorenzo in 2010. Stewart is consistent with Herald, saying like there's an inconsistency in the verdict and you can't move forward with that. Lorenzo is saying something a little bit different, but I think it's distinguishable. I think if you disagree with Lorenzo, you don't have to certify conflict, because that case I think was more focused on the improper questions that were asked of that expert that were both sexist and racist, or sorry, not racist, but inappropriate. They were just inappropriate questions that were asked of that expert. And we don't have that kind of situation here. You read through the record, you know, it's a hard fought trial, but there are no situations where somebody like a lawyer is attacking a witness for some improper reason. So I think you could distinguish Lorenzo fairly easily. I'm happy to keep talking about the future damages, but I think we kind of ended up at the spot with this case from the 5th DCA, and it seemed like you were very focused on that. Is there anything else you'd like to talk about with the future damage? I think that the past damages seems fairly straightforward, that has to be affirmed. The future damages is something that you're perhaps a little less sure of.
Well, how sure are you?
I think it can be, because I think, you know, you read the evidence in the light most favorable to the verdict, and you look especially at what the jury's been instructed to do. And here I think it's fairly clear that they got some testimony from Dr. Bono and Dr. Nesbitt that certain services were necessary to be done in the future.
So the Lofton case from the Florida Supreme Court dates back to 1972. In that case, the court basically reiterated damages, future medical are only for those that are reasonably certain to be incurred. And then it talks about the evidence that would support that. And it also includes a reference to mortality tables, because then the question becomes, well, how many MRIs might be necessary could be dependent on how long the person lived. Was there evidence of a mortality table in this case?
There was a demonstrative that was put in during closing arguments.
So
and he
it's
said,
not submitted to the jury as evidence for.
I didn't see a spot in the record where it was introduced as evidence. It was shown to the jury. The jury knew what his age was. So they knew he was 61 years old. And then the demonstrative says, you know, he's likely to live another 15 to 20 years. So the jury could use the demonstrative. They could also rely on their just general knowledge of what an American's average lifespan would be, and they could calculate the numbers based on that. They could also decide that he looks, you know, maybe a little healthier than the normal person. He's going to live longer, or they might think, oh, he's going to live a little bit shorter.
The doctor testified that his surgery was successful, and the jury found no permanency. So it does seem to raise a question as to what led to the jury being reasonably certain as to the $50,000 being necessary. And the doctor said, I don't have it in front of me, but I believe his testimony was reasonably likely. And it goes through the words, if I remember correctly. It does seem to invite some speculation based on what the jury was given.
Right, but what Dr. Bono is talking about is really, it's like some of the stuff is treatment stuff and some of the stuff is diagnostic stuff. And like they're both of the experts are crystal clear. Like this guy needs MRIs every 2 years based on the records, which actually, if you were to use your common sense, you know that those prices are going to go up over time because of inflation. Even without inflation.
This record leads the jury to speculate about what the cost is going to be, how long is he going to live, how much is it going to add up to. These are questions that still remain.
I don't think that's speculation so much as it's just like, here's the evidence and make a decision on what is likely to happen here. And that's the kind of thing that we ask juries to do every day. They're given evidence, they're presented with a plaintiff, and they're told by expert witnesses he needs MRIs every other year, he needs x-rays every year. By the way, here's a bill for what that costs when he goes to this guy. And so the arithmetic's not really that difficult. You just need to look at that part of the record, which is like, you know, the jury could have easily done that. That's what I did. You look at, you know, record pages 217 through 231, you see the prices for MRIs, you see the prices for x-rays. You know, you get some guy with a sheet of paper, you do the arithmetic, and you come up with a number that pretty easily gets you to $60,000 or $65,000. And then they came down to 50 for whatever reason, but that's the kind of thing the juries naturally do every day. So I think this is overall a judgment that is you affirm the 150,000 past damages. I think is almost crystal clear. That he testifies that this is what it is. The jury wasn't asked to connect the concept of permanent injury with the recovery of past economic damages, so that gets affirmed. On the future damages, I think there's enough here that the jury could have made the decision appropriately, not by speculating, but by looking carefully at the evidence and doing arithmetic, which is what we ask juries to do all the time. So, were there any further questions, Judge Silverman?
No.
No. Okay.
Thank you.
So we ask you to affirm.
Thank you. I guess in rebuttal, I would just encourage the court to consider that city's position is that you can't necessarily separate Dr. Bono's opinion that the surgery was for a permanent injury from the actual need for the surgery later on. So
I think you spent a lot of time on the past, that issue in the past medical.
yes,
And
and
what address the future medical issue that we just talked about?
well, on the future, it is entirely speculative what the jury did by coming up with the 50, because there was no testimony that said that he would need future treatment according to Dr. Bono related to the temporary injury. So because of that, there's no reason for the jury to come up with anything. And also, just as a factual matter, the last time that the plaintiff had treated was several years before the trial. I believe it was in June of 2018. So it was well before, so he hadn't been treating with anyone at all. So as a practical matter, there was a deficiency in the evidence there. And then there's a deficiency in the evidence from Dr. Bono saying that he didn't, he never recommended treatment related to the non-permanent injury. So we would encourage, the city would encourage the panel to reverse the motion, the denial of the motion for remittitor. I mean, essentially, you just don't get to those numbers without resorting to speculation. You don't get to those numbers if you reject that there's a permanent injury. And I don't think you can separate Dr. Bono saying permanent with the need for surgery. He didn't get surgery for a non-permanent condition. That was never part of the testimony. Thank you.
Very good. Thank you both very much. The next case on the docket is, this is Matthews as personal representative of the estate of Pat Home versus the estate. I understand we have one counsel signed in. Is anybody here for this case? So it looks like Mr. Spivey may still be outside. We're going to take a recess. We're still waiting for some other attorneys to come in, and you will let us know when they are.
All rise.